Greetings, I'm Judge Kathleen McCarthy, one of your county court judges in the 17th Judicial Circuit, Broward County, Florida. Today I will talk about small claims court. A small claims case is a legal action filed in county court to settle minor legal disputes among parties where the dollar amount involved is $8,000 or less, excluding costs, interest, and attorney's fees. A small claims action begins by filing a statement of claim with the Broward County Clerk's Office. Forms that have been approved for statewide use are located within the Florida Small Claims Rules. The Broward Clerk of Court may also be able to provide you with copies of appropriate forms. Filing fees for small claims actions are established in the Florida statutes and local county ordinance and are subject to change by legislative action. The Clerk of Court will be able to provide information on filing fees. After filing, each person or business being sued, the defendants, must be served with a summons or notice to appear or a court date, time scheduled when the initial statement was filed. A copy of the statement of claim should be attached as provided in the Florida Small Claims Rule, so the person or business being sued knows what relief the person bringing the lawsuit, the plaintiff, is suing for. Additional fees are required for service of process on the party being sued. Generally, service of process will be made on the defendants by the Broward County Sheriff's Office. The pretrial conference. In Broward County, the Clerk of Court will schedule a pretrial conference at which all parties must appear in person. The courtroom number will be listed in the summons to appear. Please note your trial will not be heard at the pretrial conference. Court reporters. Your proceeding will not be recorded. If you wish a record of the proceedings, a court reporter is necessary. You are responsible for obtaining and paying for the court reporter. There are many court reporter agencies listed on the internet and yellow pages. Appeals to a higher court because you are not satisfied with the outcome of the trial are governed by special rules. One of these rules requires that the appellate court have a complete record of the trial to review for errors. Interpreters. It is the responsibility of any party needing an interpreter to bring a certified interpreter. Persons unable to obtain a certified interpreter must bring someone to assist in the understanding of the proceedings. The court will determine if they are qualified to interpret the proceedings. Typically, at the start of the pretrial conference, the presiding judge will explain the process to all the litigants and introduce all the mediators present. The clerk or judge will call out the names on the docket. If the defendant or defendants have been properly served and fail to appear at the pretrial conference, the plaintiff may be entitled to a default and a default final judgment. If the defendant has not been served, the court may reset the pretrial conference or dismiss the case. The judge presiding at the time of the pretrial conference may ask questions or require the plaintiff to produce documents in support of his or her claim, including proof that the defendant or defendants are not in military service. If both parties are present, the court will refer the parties to on-the-spot mediation, which will take place at the time of the pretrial conference. The mediation service is free to the parties and is designed to help litigants resolve the issues between them fairly and quickly. The mediation process enables the parties to confer fully about the case, negotiate details of the settlement, and it is hoped to reach a resolution that will be written up by the mediator. Usually, this will be a stipulation for payments and will detail the amount of the debt, the amount it is being settled for, and the amount and frequency of the payments. If the parties reach an agreement that requires the defendant to pay all or part of the plaintiff's claim, the plaintiff will also be able to recover from the defendant the court costs he or she incurred in bringing the lawsuit. If the parties do not settle the case at mediation, the judge will set the matter for trial. The small claims trial. You will be required to submit to the court any evidence you want the court to consider as instructed in the order setting your small claims trial, with a copy also provided to the other side at the same time. This includes any documents, photographs, or any other evidence. It is important that the parties understand that at the trial they cannot introduce a letter, statement, estimate, or affidavit from a witness because those things cannot be questioned by the other side. the parties will have to bring all of the witness and evidence that they wish to introduce to the trial. Also, if the party is claiming that the work was done carelessly or incorrectly or negligently, in addition to the party's own testimony, they may need to call an expert witness to testify in support of that claim. If a party has a witness that he or she wants to call and is concerned that the witness may not appear voluntarily, the party should go to the clerk of court and arrange to have the subpoena issued and served to require her witness appear. At the trial, the plaintiff, the person suing, will be required to present evidence first. Since the plaintiff has the burden of proving his or her claim by a preponderance of evidence, that is, the evidence makes it more likely than not that the claim is valid. The judge may ask questions of any witness and may permit the defendant to ask questions about it. After the plaintiff presents all of his or her evidence in the witness, it will then be the defendant's turn to testify and present evidence as well. All parties and witnesses must direct their testimony to the judge, not to each other, and are also expected to let every witness testify without interruption. After the judge has heard all of the efforts, the judge will issue a ruling. That may happen in open court immediately after the trial has concluded, and at the time the judge may offer the parties another opportunity to enter a payment plan to avoid entry of a judgment. In the alternative, the judge may take the matter under advisement and enter a judgment at a later date that reflects which party won the case and how much the losing party must pay the winning party. In addition, the judge may order the losing party to fill out a fact information sheet that contains personal information designed to enable the judgment holder to collect on the judgment. Collection on the judgment. It is important that you understand that the court will not collect the judgment for you. If you are the winning party, you must pay to record the judgment, and you will need to seek collection remedies, such as garnishment, to get the money you are owed. You can find out more about how to collect your judgment from the Broward County Clerk's Office. Good luck with your small claims adventure.